across Pakistan. We've had a lot of advances in the province of Sindh, but the appetite is absolutely correct. All the levers are being pulled in the right direction, whether it's on the supply side or on the demand side, whether it's in terms of requiring the right patronage from state institutions, the recognition, the laws, or, you know, the kind of momentum that we're seeing with the legal fraternity for the first time. So, you know, just like the climate pandemic, you know, that we're all talking about, no one would ever think that the unassuming presence of mangroves on the coastal sort of belts is what saves the global economy about $80 billion every year from flash flooding, from protecting the habitat of our sea creatures, etc. You know, they're just mangroves, but an investment in them goes a long way. I believe just like planting those mangroves, we have started planting the seeds of what is the only viable solution for the justice disaster that we're seeing before us right now, and that is ADR. The momentum is right, and we have market leaders over here who are truly the consumers of this, and these are simple market principles at play over here, demand and supply. We're seeing the right you that has to, in your individual capacity, make that correct decision. One corporate entity at a time, one regulator at a time, coming on board the bandwagon of promoting ADR across Pakistan. That is what is going to set the right signals across this market space right now, because truly that is what it is. And together, then we can come and really work towards the kind of prosperous, thriving Pakistan that we all know of, have read of, perhaps some of us have experienced, but all really desire to see again. Thank you very much, ladies and gentlemen.
May I now request on stage Justice Arif Hussain Khilji, former judge of the Supreme Court of Pakistan and managing director at Musaliha International Center for Arbitration Dispute Resolution, to please kindly come up on stage and commence the conference.
अस्सलाम वालेकुम जी। सबसे पहले तो जस्टिस एजाज साहब बहुत बहुत शुक्रिया। आज हम यहाँ जो जमा हैं इसका सब में बड़ा क्रेडिट मैं जस्टिस एजाज साहब को दूंगा कि इन्होंने बहुत इसमें हमारा साथ दिया, और इस्लामाबाद में हमने कई एडवोकेट्स को ट्रेन भी किया है एज ए एक्रेडिटेड मीडिएटर्स। मैं ज़्यादा लंबी चौड़ी बात नहीं कर सकता क्योंकि हया ने जितनी अच्छी स्पीच की है उसके बाद मेरे लिए कुछ कहना बहुत मुश्किल काम हो गया है, और वैसे भी मुझे घर में बोलने की इजाज़त नहीं है, तो मैं कोशिश करता हूँ कि बाहर भी कम बोलूँ, कहीं आदत ख़राब ना हो जाए और घर जाके बोलना शुरू कर दूँ। बात यह है कि करीब 50 साल से कुछ ऊपर लीगल रहा, फिर हाई कोर्ट में रहा, फिर सुप्रीम कोर्ट में रहा, और जब तक मैं ये सारी चीज़ें करता रहा मैं यही समझता था कि पाकिस्तान में दूध की नहरें बह रही है, इंसाफ के शहद बह रहे हैं और किसी आदमी को कोई प्रॉब्लम नहीं है। मगर जब मैं रिटायर हुआ तो इरादा तो ये था कि अब बहुत अर्सा हो गया, कुछ अब लाइफ को एंजॉय किया जाए, तो फोटोग्राफी का थोड़ा बहुत मैंने प्रोग्राम बनाया था कि अब फोटोग्राफी करेंगे, और बेटे ने हमारे माशाल्लाह कहा कि अब्बू मैं आपके लिए एक 4 व्हीलर गाड़ी ले लेता हूँ, आप उसमें 2-3 दिन के लिए निकल जाया करें। अब इसे मेरी बदकिस्मती कह लें, खुशकिस्मती कह लें कि रिटायरमेंट से 1-2 दिन पहले हया मैडम हमारे घर आई, कहने लगी आप क्या करने का इरादा कर रहे हैं रिटायर होकर। मैंने कहा भाई इरादा तो यही है, ये कैमरा खरीद लिया तुम्हारे सामने रखा हुआ है और मैं जाके नेचर की फोटोग्राफी करना चाहता हूँ। बोला ठीक है आप कीजिएगा ये काम, मगर थोड़े दिन हमारे ऑफिस में लीगल एड सोसाइटी के ऑफिस में आए। कुछ एक हमारे जो माशरे का रख रखाव है कि कोई बच्ची घर पर आकर कुछ कहे तो आदमी स्टेट अवे उसको नो नहीं कह सकता है। तो मैंने कहा ठीक है, दिल में ये सोचा था कि 1 महीने तक बैठेंगे फिर इसके बाद आ जाएंगे। जब मैं वहाँ गया तो आप लोगों को कहूँ यू बिलीव इट कि फॉर द फर्स्ट टाइम आई रियलाइज that what difficulty a common man is facing to access the justice. What are the problems? How miserable their life is. एक तो lack of awareness about the law उन्हें लॉ के बारे में मालूमात नहीं होती थी। एक हमारे यहाँ एक बहुत बड़ा तबका ऐसा ख्वातीन का है जिन्हें ये मालूम नहीं है कि उनकी जायदाद में हिस्सा उनके वालिद की जायदाद में, उनके शौहर की जायदाद में, उनके बच्चों की जायदाद में अल्लाह ताला ने कुरान शरीफ में भी दिया है, कानून में भी रिकग्नाइज है, मगर उन्हें नहीं मालूम होता है। तो इन चीज़ों को देखने के बाद 2012 से लेकर आज तक वहीं फंसा हुआ हूँ और आई एम एंजॉइंग माई लाइफ। जहाँ तक के मीकेडर का ताल्लुक है जिसके लिए आज हम यहाँ जमा हुए हैं, तो अगर आप जो इंडस्ट्रियलिस्ट यहाँ बैठे हुए हैं वो ये बात बहुत अच्छी तरह जानते हैं कि जब भी कोई ऐसा मुकदमा जिसमें डिस्प्यूट बिटवीन द सप्लायर और परचेजर हो या दो इंडस्ट्री के दरमियान में इंपोर्ट और एक्सपोर्ट का कोई प्रॉब्लम हो या किसी इंटेलेक्चुअल प्रॉपर्टी राइट्स के बारे में कोई प्रॉब्लम्स हो, तो अगर ये कोर्ट में जाता है तो फिर एक बहुत तवील अरसे तक उन्हें कोर्ट के अंदर ये लिटिगेशन करना पड़ती है। और इससे ज़्यादा बुरा चीज़ जो होती है वो ये है कि दो इंडस्ट्री जो होती है, दो बिजनेसमैन जो होते हैं, उनके ताल्लुकात स्टैंड स्टिल हो जाते हैं, वो फिर आपस में डील नहीं कर पा रहे होते हैं। तो एडीआर एक ऐसा मैकेनिज्म है जिसके ज़रिए ना सिर्फ ये कि वो अपने डिस्प्यूट को बहुत इजीली एमिकेबली आपस में तय कर सकते हैं और वो बातें जो अदालत में वो कह नहीं सकते हैं। बहुत दफ़ा आपके अकाउंट्स होते हैं, आपकी कॉन्फिडेंशियलिटी होती है बिजनेस की, वो आप अदालत में बताना नहीं चाहते हो ओपन कोर्ट में एविडेंस में, वो आप मीडिएशन में कमरे के अंदर बैठकर बता सकते हैं कि इसमें कागज़ पर रेट ये लिखा गया था, एक्चुअल रेट ये था, सो ऑन सो ऑन। तो ये मीडिएशन के ज़रिए ये मसले बहुत आसानी से हल हो सकते हैं। ज़रूरत इस बात की है कि हमारे जो लोग कॉन्ट्रैक्ट बना रहे हैं वो अपने कॉन्ट्रैक्ट के अंदर ये क्लॉज रखें कि इन केस ऑफ द डिस्प्यूट दे विल फर्स्ट रिजॉर्ट फॉर द मीडिएशन। और अगर खुदा ना खास्ता मीडिएशन फेल हो जाता है, जिसके इम्कानात बहुत कम है, मैं इम्कानात कम होने की वजह ये कह रहा हूँ कि मुझे इत्तफाकन कुछ ममालिक में जाने का चांस मिला, वहाँ जाकर जब स्टडी की तो मीडिएशन का सक्सेस रेट बिटवीन 60 to 70% है। अब 60 to 70% अगर केसेस मीडिएशन के ज़रिए रिजॉल्व हो जाते हैं तो ये बहुत बड़ी फिगर है। तो हमें इस चीज़ को ट्राई करना चाहिए। हमारे पास इस्लामाबाद में भी ट्रेन मीडिएटर्स मौजूद हैं और कराची सिंध के अंदर भी मौजूद है। हम गिलगित बल्तिस्तान में मई में जा रहे हैं मीडिएटर्स को ट्रेन करने के लिए। इंशाल्लाह कुछ अरसे में हम बलूचिस्तान में भी मीडिएटर्स ट्रेन कर रहे हैं। तो आपको ये सहूलत क्रॉस द पाकिस्तान मिल सकती है। आपका कहीं पर भी डिस्प्यूट हो, हम ये डिस्प्यूट को रिजॉल्व कर सकते हैं। आप कोशिश करें पहले अपने मसले को हल करवाने की, तो इंशाल्लाह आप लोग को देखेंगे कि बड़ा पॉजिटिव रिजल्ट निकलेगा। मैं जब इस्लामाबाद आ रहा था तो मेरे दिल में कहीं ये था कि अल्लाह ने चाहा तो जो ये आप लोग यहाँ आए हुए हैं तो आप लोग इसका पॉजिटिव रिस्पांस देंगे। मीडिएशन में आपका कोई नुकसान नहीं है, अगर आप ट्राई करेंगे मैक्सिमम ये होगा फेल हो जाएगा, मगर इसके चांसेस बहुत कम है। तो आप कोर्टों में जाने से पहले कोशिश ये करें कि अपने मसलों का हल मीडिएशन के ज़रिए करें। सिर्फ एक आप में कॉल करें, हमारा मीडिएटर्स आपके मसले के लिए मौजूद होगा, ट्रेन मीडिएटर्स होगा। वी हैव ए लिस्ट ऑफ मीडिएटर्स, आप उसमें से सेलेक्ट कर सकते हैं। अभी रिसेंटली इस्लामाबाद हाई कोर्ट ने एक बहुत बड़ा केस था, उसके अंदर मीडिएटर्स की लिस्ट पार्टीज को दिखाई, पार्टी ने उसमें से आउट ऑफ दैट मीडिएटर लिस्ट एक मीडिएटर के नाम पे टिक किया और वो केस अब चल रहा है। और इंशाल्लाह आई होप कि अल्लाह ने चाहा तो पार्टी की रजामंदी से वो हल हो जाएगा। तो आप लोग इसकी को ट्राई करें तो बहुत ही अच्छा रहेगा आप लोगों के लिए भी और हमारे सोसाइटी के लिए भी। इस वक्त जो हमारी माशी सूरत हाल है, उस मासी सूरत हाल में इंडस्ट्री को प्रोटेक्शन चाहिए, बिजनेसमैन को प्रोटेक्शन चाहिए, उसका जो इन्वेस्टमेंट है उसको बेस्ट पॉसिबल वे में प्रोटेक्शन देने की है। और वो प्रोटेक्शन उसी सूरत में मिल सकती है जब आप अपने डिस्प्यूट को एमिकली रिजॉल्व करने के लिए मीडिएशन को अडॉप्ट करेंगे। बस मैं इससे ज़्यादा बात करूंगा तो घर वाले नाराज हो जाएंगे। थैंक यू वेरी मच।
थैंक यू वेरी मच सर। मैं दावत देना चाहूँगा Honorable Mr. Sulaiman Chawla Sahab ko, who is an industrialist from Karachi and the Senior Vice President of the Federation of Pakistan Chamber of Commerce and Industry, who is a member of the Musaliha International Center for Arbitration and Dispute Resolutions Board of Governors and a platinum member of MICADR. Sir, please.
Bismillah ar-Rahman ar-Rahim. Justice Arif Hussain Khilji, former judge of Supreme Court, distinguished members of the business community, honorable judges, excellencies and dignitaries, member of Pakistan's social development landscape, mediator, mediation advocates, ladies and gentlemen, Assalamu alaikum. On behalf of FPCCI and on my own behalf, I feel immense pleasure to be the part of this conference on alternate dispute resolution, the future of dispute resolution and opportunities for the industry. The Federation of Pakistan Chamber of Commerce and Industry is the apex representative body of entire trade and industry of Pakistan, approximately 252 trade bodies, including 66 chambers of commerce, 24 women chambers of industry, 12 chambers of small traders, 4 joint chambers, and 146 all Pakistan associations representing industry, trade, and services sector are affiliated with FPCCI. The FPCCI itself is also attached with major global trade organizations, hence we are serve as an apex national institute on private sector in Pakistan. Being the apex representative, we receive complaints regarding dispute, also seek resolution and always prefer amicable produce pertinent judgment of a high quality. Realizing the potential economic and social impact of government and the judiciary of Pakistan have made the institutionalization of alternate dispute resolution a national priority and business community is fully supporting it. A task force created by Supreme Court of Pakistan to institutionalize ADR across all territorial jurisdiction in the country and the expedition measure of the Islamabad and Sindh High Court in this regard are the testament to this. The recent establishment of the Accreditation Committee in Islamabad to recognize the accredited ADR center and mediator and the fact that the composition includes representation from FPCCI is a step in a very right direction. Although the practice of using trustworthy members within the industry to facilitate dialogue between two disputing parties is common practice in our industry, the time has come for us to adopt the modern and systematic techniques to have proven successful around the world. This means first and foremost mediation through trained professional who knows the art of science and dispute resolution of conflict management. Establishment of a robust alternative dispute resolution regime is directly linked to ease of doing business in inflow of foreign investment. Judicial delay and lack of ADR service not only hamper business confidence in the country, as corporate entities do not find effective dispute resolution service, but also discourage foreign investment, particularly from regions where investors are used to highly developed ADR system. Businesses and investors have three primary incentives when it comes to dispute resolution: cost, time, and confidentiality. ADR laws of Pakistan guarantee all these three. The Islamabad ADR Act 2017, Punjab ADR Act 2019, amendment to section 89A and B of the CPC in Sindh and KPK ADR Act of 2020. All officially recognize mediation and arbitration as ADR process and allow for the mediation settlement agreement to be made a rule of court ensuring judicial enforcement and ensure complete confidentiality of mediation proceedings. Being the apex representative body of trade and industry, the FPCCI feel its responsibility to propose to the government and other relevant stakeholders workable model and intervention that create favorable business climate. The collaboration with MICAD for this conference is testament to our trust and support of mediation, a viable dispute resolution mechanism to resolve key dispute, particularly between industry and regulatory bodies. This will also a monumental step to attract foreign investment even during testing time such as ones we face today. Our proposal to regulator representative of the State Bank of Pakistan such as FBR etc. is to revise their dispute resolution framework to incorporate the effective tool that mediation has to offer. The industry is willing to sit on the table. Let us come together and resolve our disputes through settlement and dialogue in a systematic manner. While I am concluding, I am very optimistic that the mechanism of alternate dispute resolution shall be unworkable to benefit of a stakeholder. May we all the worthy of Allah mercy. Thank you very much.
Ladies and gentlemen, thank you very much. Chawla sahab, बहुत aapka shukriya. Before we move ahead, I would like to present to you the scale of the problem at hand today and why we feel, and the government and the judiciary now feels, that mediation is one of the only viable solutions to resolve this problem. Ladies and gentlemen, there are 2.1 million pending cases in courts all across Pakistan. The total number of judges, from the junior most judge in the district right up to the Chief Justice of Pakistan, is 3,067. On average, it takes approximately 15 years for a civil suit to conclude. This mathematical equation does not make sense. It is 9,000 cases in 1 year alone. But the number of cases that were coming in that year alone was 16,000, which led to an increase in net pendency at the level of the Supreme Court. The same is the picture at all high courts and all district courts. The reason why we have invited the industry to be at this forum where the judiciary is present and the respected internationally accredited commercial and civil mediators are present as well is to explain to you that your pain points when it comes to dispute resolution are four, as we understand. Your cost, your time, your confidentiality of business documents, and your business relations are essentially what matters most to an industry. Alhamdulillah, after 2017, right up till today, provincial ADR laws of Pakistan guarantee all three as far as mediation is concerned. Arbitration and litigation have their disadvantages, ladies and gentlemen. Not only when a party goes into litigation, they have to face a massive backlog, but arbitration and litigation, both because are subject to a decision, are damaging for business relationships. They are time-consuming processes. The arbitration, especially an arbitration between a domestic party and a foreign party, is extremely expensive. Apart from that, litigation and arbitration both are relatively impersonal. The problem does not belong to you anymore. It belongs to the lawyer who's representing you. The issue belongs to the businessman or the industry. It is taken away, and the pleadings are made by the lawyers or whoever is representing them. It is unpredictable. You can never with certainty guarantee that the outcome that you get is going to be a win-win scenario for both parties. It is not flexible. You cannot engage in a dialogue or a discussion whereby you're proposing your own solutions suited to your own business environment. The judgment is subject to an appeal. An objection in an arbitration case in our system is almost as good as an appeal, but the appeal process adds to the court pendency, adds to the cost, adds to the time. Ladies and gentlemen, the world has moved to alternative dispute resolution. Alternative dispute resolution is essentially a recognized mechanism of settling disputes outside of courts. इसके मुख्तलिफ अक़साम होती हैं, लेकिन दुनिया में सबसे जो मशहूर अक़साम हैं उनमें मीडिएशन, आर्बिट्रेशन, कंसिलिएशन एंड न्यूट्रल इवैल्यूएशन शामिल हैं. अल्लाह का बहुत फजल है कि अब पाकिस्तान में आर्बिट्रेशन तो हालांकि 1940 से recognized है, 1947 onwards recognized है under the 1940 Arbitration Act, but now your provincial alternative dispute resolution laws recognize and judicially enforce settlement agreements of mediation proceedings as well. Mediation में एक थोड़ा सा जो, especially when we go to the industry, because MIC ADR, alhamdulillah, has reached out to the industry and has gotten an overwhelming response. Industries such as Al-Karam Textiles, Gul Ahmed, Ismail Industries are now platinum members of MIC ADR. But whenever we go to an industry, whenever we go to a chamber, the first thing we hear is, but we do this already. हम अपनी इंडस्ट्री में किसी एक बड़े को जिसको हम ट्रस्ट करते हैं उसको टेबल पे बुलाते हैं और दोनों पार्टीज उनके थ्रू एक मामले को सेटल करने की कोशिश करती हैं, even though that is slightly close to what mediation is. But a mediation is a very carefully crafted scientific process that has to be in the hands of an accredited, trained individual who knows the art of dispute resolution in order to bring two disputing parties in a complex commercial, civil or family matter to a mutually beneficial settlement agreement. इसके चार key components हैं. One, the person in the room who's conducting the mediation needs to be trained. The standard for international trainings and also the standard now laid down by the Islamabad High Court under the accreditation rules of 2023 is minimum 40 hours of training in accordance with international standards. Number two, it is a carefully crafted process whereby a mediator engages with both parties in private sessions when emotions and issues are on the table. He then very carefully at the right time, which the training sort of helps build those skills in him, brings the parties together in a joint session and starts to negotiate over options on the table until the parties can reach a settlement on their own. Third, there is no appeal to a settlement agreement क्योंकि यहाँ पे arbitration की तरह या litigation की तरह order या award नहीं दिया जा रहा, ये एक राजीनामा sign हो रहा है between two parties who have mutually agreed to come to these settlement terms. There is no appeal. The third is it is judicially enforceable. By under the ADR laws that I'll be mentioning later, a settlement agreement now in Punjab, Sindh, Balochistan, Khyber Pakhtunkhwa, Islamabad, and inshallah very soon Gilgit-Baltistan, when is submitted before a civil court, will become a rule of court, will become a court decree. What that means is that if one party now backs out from the settlement agreement, he is not just backing out of a contract, they're now backing out of a court decree. Ladies and gentlemen, ये वो तमाम laws हैं जो पाकिस्तान में mediation को recognize करते हैं और judicially enforce करवाते हैं. We highly encourage the industry and the businesses to ask your legal teams to start digging out these laws and advising you on how your particular entity can benefit from them. The Islamabad ADR Act of 2017, the Sindh amendments to the CPC in 89A and 89B, the Punjab ADR Act of 2020, the KP ADR Act of 2020, and the Balochistan ADR Act of 2020, and inshallah very soon, hopefully in April or May, the model mediation law that we are currently working with the Honorable Chief Judge of Gilgit-Baltistan will be implemented in GB as well. This is not a new concept. दुनिया के तरक्की याफ्ता और बहुत से तरक्की पजीर ममालिक ऑल्टरनेटिव डिस्प्यूट रेजोल्यूशन और बिलखसूस मीडिएशन को के इकोसिस्टम्स को डेवलप इस हद तक कर चुके हैं कि मीडिएशन के certain subjects of law have become mandatory for mediation before a party can approach a court. These are all countries, and not all of them are on the map, where mediation systems have been established. And alhamdulillah, under the guidance of Justice Nasir Aslam Zahid and Arif Hussain Khilji, and under the patronage of the Islamabad High Court, the Sindh High Court, and the Gilgit Chief Court, we've managed to put Pakistan on this map. Ladies and gentlemen, इसके advantages क्या हो रहे हैं, मैं ये सिर्फ आपको बताना चाह रहा हूँ. From an industry's perspective, so that you know that this system works. In Turkey, the mediation law came about in 2012. We visited Turkey with a delegation from Pakistan in 2022. In 10 सालों में Turkey managed to successfully resolve 3 million cases through mediation. Civil mediation, commercial mediation, and labor cases, civil, commercial, and labor cases are now mandatory for mediation in Turkey. A party cannot approach the court if mediation has not been exhausted prior in certain cases, non-criminal cases. Ladies and gentlemen, the UK. The Center for Effective Dispute Resolution is one of the apex ADR organizations in the world, right up there with the Chartered Institute of Arbitrators London, with the International Mediation Institute. ये उनके numbers हैं जो हम आपको यहाँ पे present कर रहे हैं. The United Kingdom, since 1990, has mediated cases जिनकी total worth was 195 billion pounds. हर साल approximately 20 billion pounds के cases mediation में जाते हैं, जिनसे businesses को सालाना approximately 6 billion pounds की savings होती हैं in terms of litigation costs, in terms of business relationships that have not been damaged, and in terms of time. So internationally, the system works. You won't believe this, and a lot of us don't, because the legal structure of China is perhaps not open to a lot of transparency. But in 2020 alone, there were 5.1 million cases that were settled in China in 1 year through the court's own mediation platforms. And this is the same mediation that level that IMI, CIR, CEDAR, जिस process को follow process के through China में court के अपने ADR centers में 5.1 million cases rate that Honorable Justice Khilji was talking about is 65%. Of all cases that went to mediation, 65% actually got a settlement agreement, and like in Pakistan, China, maybe there is no appeal to a settlement agreement. Ladies and gentlemen, some pictures of our hosts in Turkey were gracious enough to have us visit the Supreme Court, ADR centers. We met a lot of mediators. One of the general managers of Turkey's Apex Chamber of Commerce, the TOB, Ayum is Turkey's Chamber of Commerce's own dispute resolution center, which is one of the largest dispute resolution centers housed within a chamber in all of Europe. Ladies and gentlemen, we were hosted by them as well, and the general manager will inshallah be joining us online today. Why opt for mediation? Why opt for this particular form of ADR? One, it is faster. The lawyers in the room know this, the judges of course obviously do, but the industry needs to be told this. Pakistan ke ADR kawaneen ke mutabik, the maximum time allotted for a mediation is 30 days, 30. The mediator, if he feels that he needs more time for a settlement to be there, or if he needs more time to mediate the case, can request for an additional 15 days, 1-5. So it's time effective, it's faster. Ideal mediations, an excellent mediator will successfully resolve or settle a dispute worth millions of dollars in a day or two. That's how effective the process is. Become effective through iterations of 20 years. We are bringing the same process to Pakistan. In costs, आपके सामने जो USB पड़ी हुई है, वो MIC ADR के उसके अंदर कुछ documents हैं. तमाम ADR laws उसके अंदर हैं. उस USB में हमारा जो एक presentation, हमारा fee schedule भी है. Mediation, of course, you have to pay for it. You have to pay for the mediation advocate's fee as well. But the costs are considerably less as compared to a litigation or as compared to an arbitration. For those industrialists who deal with foreign parties, we have the Special Technology Zones Authority. Economic zones are hubs of dispute resolution ecosystems because you're dealing with foreign investors on a daily basis. In an arbitration, you need to either be a signatory to a convention or the seat of arbitration really matters. In a mediation, the settlement agreement can be enforced in jurisdictions without it invoking a particular convention. Even though the Singapore Convention is there and we're working with the government of Pakistan to ratify it, but a settlement agreement is like a contract. A breach of contract in a foreign jurisdiction will, reduce the chances of there being, a win for the other party or the breaching party if it ever goes to litigation. So the chances of a foreign party where ADR systems are developed backing out of a settlement agreement are almost minimal. Ladies and gentlemen, it's flexible. In a courtroom or an arbitration setting, it is very, very difficult for two parties to come together, talk to each other, and figure out options and put options on the table that suit their particular industry, their particular business environment. But a mediation allows you to do so for as long as you want to, as long as you conclude it in 30 days. But it is a party-centered process, and the party is able to table solutions or design solutions which suit the needs of that particular industry. Turkey mein, specializations hai mediation ki, even though it's a nascent system. Sports industry ki mediation ke alag mediators hain. Oil and gas, energy, telcos, banking, insurance. These are specializations in mediations. Confidentiality, as per the laws of Pakistan. The minutes of a mediation proceedings or details of a mediation proceeding ke mediation mein kya baat hui thi cannot be presented in a court of law as evidence. When we are taught accredited mediation ke courses, the primary emphasis is on confidentiality. If you are in a private session with a mediator, the mediator cannot disclose information to the other party without your express approval. And overall, when both parties are in that mediation, no details of that mediation can be submitted even in a court as evidence. The mediator is, of course, supposed to present a mediation report to the court, but that does not include the confidential details that you might want to table during a mediation setting. Number 3, sustained relations. Attack the issue, don't attack the party, is a principle that has been taught in mediation trainings around the world. The party is not the problem. You would want to engage with the business for your profits. You would want to keep those relationships existing. You want the issue to be resolved. But if you're taking the other party to court and he's lost the case or you've lost the case, chances are you would not want to be in business with that particular party again. What are the kind of cases that are primed for mediation? Almost all civil, commercial, family nature of cases, and even criminal cases in certain jurisdictions, compoundable cases with up to 3 years of punishment, can be diverted from courts or directly by parties without even going to court through a mediation center or a mediator in mediation. So you have your regulatory matters. The ADR, the Federal Bureau of Revenue, FBR, have their own ADR bylaws, which of course need to be tweaked in order to match this system. However, regulatory bodies के साथ भी mediation मुमकिन है. Commercial disputes, contractual, professional negligence, companies and banking matters, insurance matters, almost every kind of matter that a business might face, a labor matter, primed होते हैं. So again, just discussing some of the kinds of disputes. So when you're in a mediation, when you